All right, here we go. Looking at criminal law. All right, yeah, let's get right into it. So to introduce criminal law, we're going to go over a couple things, right? Its key functions, how it contrasts with tort law, and kind of its definition in reverse order from how I originally talked about it just then. So, definition and scope. Criminal law is a branch of the law that's addressing offense against society as a whole, focusing on public wrongs. It's a public form of law as opposed to private. It defines behavior deemed intolerable by society and prescribes punishments for those who violate those norms. Okay. How does it contrast with tort law? When we were talking about tort law, we talked about how tort law contrasts with criminal law. We kind of touch on the exact same things here, but from the other perspective, right? So, again, kind of like we said, well, tort law primarily deals with things like private and civil wrongs and disputes between individuals, with compensation and remedy being a focus of the resolution to that dispute. Criminal law, on the other hand, focuses on public wrongs and violations that disrupt social order, and then prescribe convictions or determinations by a court determining guilt accordingly, right? So tort law focuses on compensation and liability and probability of having done a thing, while criminal law focuses on intent and, most importantly, guilt beyond a reasonable doubt, and that must be proven. Key functions of criminal law, deterring certain behaviors in the public through the threat of punishment. Specific or general deterrence, right? General, specifically referring to trying to deter the public, versus specific referring to a certain individual and making an example out of them. Through that deterrence, it's important to point out the likelihood of punishment is more effective than the severity of the crime when it comes to punishment in criminal law. That's also why we kind of don't really use the death penalty too much anymore. Capital punishment, America does now under Trump, but typically we found it not only is it incredibly expensive, but the severity of the crime isn't as effective as the chance of you being punished, right? Reprehension, that's another function of criminal law, maintaining order of society, accountability, holding individuals accountable, and rehabilitation. Right after all that shit is done, we aim to reform offenders and reintegrate them into society. Categories of criminal offenses. Let's go through these really quick. So, again, criminal law is under the jurisdiction of public law. It's an area of law concerned with public interests, and it regulates collective interests. That's essentially what public law is. Again, criminal law fits into that. Criminal offenses typically classified into three broad categories. So the three broad categories that criminal offenses are classified into are offenses against persons, offenses against property, and offenses deemed wrong in and of themselves, also known as social order or victimless crimes. Let's go over those really quickly. So, what is an offense against a person? It's, as the name suggests, it's a crime that directly harms an individual. Things like assault, things like homicide. We have three levels of assault within that. In order, general assault, so first degree. Second degree would be assault causing bodily harm, or assault against a police officer. And third degree would be aggravated assault. These are the three levels of assault, right? General assault, assault causing bodily harm or against a peace officer, and aggravated assault. Next, we have offenses against property. This is offenses that involve damage or interference with another person's property. There are two degrees, there's two levels. There's theft under 5K and theft over 5K. Those are our offenses against property. And finally, we have offenses deemed wrong in and of themselves, right? These are acts that society prohibits, not necessarily because they harm an individual directly, but because they're considered inherently unacceptable. Things like certain regulatory or moral offenses, drug possession, prostitution in itself. These are our public social order crimes, our victimless crimes, our offenses deemed wrong in and of themselves. Just to go through that one more time, the way that our criminal offenses are classified are into three: offense against a persons, against property, and deemed wrong in and of themselves, right? What are the debates surrounding criminal law? Naturally, it would and is highly contested due to the stakes at play. So We debate about what constitutes crime, what constitutes deviance. We debate about policy, right? The effectiveness of the law. How do laws balance protecting society and safeguarding individual rights? How effective the law is. Do certain laws produce negative social outcomes? Et cetera, right? These kind of very meta criminal law based conversations that are commentaries on society as well, right? Let's go to the next thing. This is going to be really important, so pay attention here. Fundamental elements of a crime. So the two principles that constitute a crime and that criminal law moves around, essentially both practically and philosophically, are actus reus and mens rea. Actus reus is Latin for the wrongful act, while mens rea is Latin for the wrongful mind. And we'll get into that, but before that, we got to consider what's called the simultaneous principle, or the principle of simultaneity. It's this idea that a crime requires both the simultaneous coincidence of actus reus and mens rea for it to exist. So, yeah, simultaneous principle. Crime requires the simultaneous coincidence of actus reus and mens rea. What are actus reus and mens rea? Actus reus is the wrongful act, or the actual crime itself that's breaching the law, and mens rea is the wrongful mind, or the mental state required in order to commit a criminal act, right? The intent behind the act. Yeah. Moving on specifically in assessing mens rea, there are two different assessments of mens rea. And this is objective intention and subjective intention, right? Because mens rea is essentially intent. Under that intent, we have objective intention assessment and subjective intention assessment. So we'll go through those one by one. Objective intention, what is that? Well, when we're looking at objective intention when assessing mens rea, we are considering what would be in the mind of a reasonable person, generally given the circumstances. Before we continue, what is a reasonable person? A reasonable person generally is who kind of this arbitrary archetype of this person that the judge deems as the reasonable actor within a given situation. And then we kind of judge the specific individual at large by that reasonableness standard. So let's continue, right? So objective intention, we're considering what would be in the mind of a reasonable person given the circumstance, right? What would be in the mind of a reasonable person when doing that thing? This is what you, the person at large, the defendant, should have known or should have done in the particular situation, right? That's what objective intention is. This is what you should have known. Subjective intention, what is that? This is considering what would be in the mind of the person committing the crime or the defendant, specifically at the time of the act being conducted. So this is recognizing the foreseeability of the time at the time from the perspective of the person committing the crime, right? This is what the person does know specifically in a particular situation. Yeah, so just to go over that again really quickly, we assess mens rea through two different things. Objective intention, which is where we're considering what would be in the mind of a reasonable person, what you should have known as the defendant. And subjective intention, what is in the mind of the actual person doing the thing, what is the defendant thinking specifically, right? Yeah, just a little bit more on these fundamental elements of crime. Under mens rea, once again, Section 21 of the Criminal Code outlines mens rea considerations regarding parties involved in an offense. The section is generally regarding aiding and abetting. So I'll read you what the code specifically says. The code says that parties to an offense may be held criminally responsible in the same way as the person who committed the offense. This is aiding and abetting. So aid as in you are doing the thing, abetting meaning encouraging to do a thing, or being directly involved in doing the thing. And all of these things, aiding, abetting, or being directly involved, would still make you partially criminally responsible unless you can prove that you were acting under duress. Now, we won't go too far into that, but essentially duress is like intimidation, force, coercion in getting you to do something. And the qualifier for that makes it very hard to prove, because if you, for example, were told that you have to, at gunpoint, you were told that you have to go home and you have to rob your family, but the person forcing you to do that stayed in the place where they were originally holding you at gunpoint, you can no longer prove that you were specifically acting under duress, or it's much harder to, because you had an opportunity in between these two events where you robbed your family and where they were holding you at gunpoint, where you could have called the police. So you would technically still be implicit in the crime. Section 21 of the Criminal Code is talking about aiding and abetting in mens rea. If you aid or abet or are directly involved in something, unless you can prove duress, you would still be partially criminally responsible. Let's move on. What are the exceptions to mens rea? We'll go through a handful of these. We're looking at 4, most importantly, for these exceptions to mens rea. Strict liability offenses, that's an exception to mens rea. In this case, the defendant must prove the absence of mens rea, because the prosecution does not need to prove mens rea. That's what makes it an exception. So, for example, let's look at reckless speeding, right? Let's say the speed sign is taken away. You don't know what the speed is, but you are still speeding. They don't have to show intent that you're speeding. You have to prove that you had no intention of speeding, right? Because regardless of the sign, the law clearly says in that area you are speeding. So this is why they don't have to show intent. You have to prove that you had no intention of doing so. So if you can clearly demonstrate that you were doing your due diligence by looking for a speed sign and it wasn't there and it should have been, you can maybe get out of that charge. Let's look at the next exception, right? Absolute liability offenses. Here, proving intent is irrelevant, or proving mens rea is irrelevant to the offense. The mere commission of the act is enough for liability. So, for example, a parking ticket is an absolute liability offense. You're either in the parking zone or not. Intent doesn't really matter. There isn't really a way to claim that you didn't know. The prosecution only has to prove that you committed the offense in itself, right? Unless, specific surrounding circumstances make it so that you don't know. For example, like in the speeding example, where all indication is that you didn't know, but it's much harder to prove in cases where absolute liability specifically is being levied. So just to go through those 2 liability offenses again, in strict liability offenses, as an exception to mens rea, it's an exception because the defendant must prove the absence of intent or the absence of mens rea, because the prosecution does not need to prove mens rea. In absolute liability offenses, proving intent doesn't matter at all, because simply doing the thing is enough for liability, right? Let's go through another example, right? Or another exception to mens rea. Culpable homicide. Here, culpable homicide is encompassing situations where homicide occurs either with intent or through actions that were unintentional yet reckless, like manslaughter, for example. Finally, criminal negligence. This involves a specific departure from the standard of care expected, showing a disregard for the safety of others. If you aren't taking into consideration the safety and welfare of others and you don't mean for them to be harmed, you'll at least be charged for some criminal negligence, though, right? Because you're still acting with negligence, negligently, intent or proving mens rea is irrelevant for a number of reasons. So just to go through those one more time, what are the exceptions to mens rea? Strict liability offenses, absolute liability offenses, culpable homicide, and criminal negligence. Before we move on, we're going to look at 2 cases regarding mens rea. R.V. Cooper is the first one. This is regarding the issue of concurrency with actus reus and mens rea. The idea of this is essentially, what if your intention changes halfway through the act of doing something? The concurrency ends halfway through the act, and you no longer intend to do what you're doing. Well, as we'll see in this case, the Supreme Court found that mens rea, or your intention, doesn't have to persist all the way through the event. It's the initial intention that counts for you to be held liable or charged, right? So in this case, R.V. Cooper. Cooper beat his wife to death. He claimed to have blacked out and had no recollection of causing the death. The thing is, he was intentionally doing something that could cause death. So he started holding her neck. For example, he was choking her out. And he was doing that by omission or by admission, he was doing that before blacking out. So he intended to choke her clearly. The intent is there. So blacking out and finishing the job didn't matter. He at one point had intent to kill her, and that's what counts. According to the judge, once he made the decision to do something with intent to cause her harm, he doesn't need to be aware of what he's doing at the moment of death. And the Supreme Court agreed he was convicted of murder. If he had claimed to black out before strangling her, though, maybe things could have gone differently, maybe not. R.V. Handel, that's another case. This is regarding an important Supreme Court decision regarding whether objective, so what's in the mind of the reasonable person, or subjective, what's in the mind of the accused when doing a thing, standards should apply case by case, right? So in this case, a truck driver had an illegal overweight load on slippery streets. He tried to beat a light, and unfortunately someone was turning. He sideswiped, killed that person. Their death wasn't intended, but they died regardless. The trial judge and appeal court concluded that the appellant's driving was departed from objective standard, what a reasonable person would have done, and that kind of shaped the way that we apply that standard. Next. What are some defenses or some mitigations of criminal offenses? So there are several different defenses that may exonerate or mitigate criminal responsibility. We're going to go through, I think, 7. We're going to go through capacity, self-defense, intoxication, excitement by police, duress, and mistake of fact. So that's 6. Let's just start at the top, right? Capacity. There are defenses to be made based on the mental capacity of the accused at the time of the crime. So, for example, mentally ill people to a degree and minors are considered to not have the ability to act with capacity for crime, for a criminal act, depending on the case. Self-defense, this is important. Self-defense in itself in Canada is permitted under Section 34 of the Canadian Criminal Code. Everyone unlawfully assaulted without having provoked the assault, and that's important, you can't provoke it, and you can't respond in a provocatory manner before the crime is carried out. Everyone unlawfully assaulted without having provoked the assault is justified in repelling force by force if the force they use is not intended to cause death or grievous harm, and is no more than necessary. Though you can use force proportionate to the threat, including causing grievous harm or death, if literally no other option exists. In Canada, again, the standard is high. You have to prove that you feared for your safety. You have to prove proportionality in response, that there was no alternative, and that the threat is imminent, so ongoing or coming. These are all things considered in self-defense, right? Especially when it comes to grievous harm or death. When it comes to base self-defense, the history of the people, the size difference, age, capacity, whatever it may be, all of these things are considered. We're going to look at a case regarding self-defense in a second, but just to recap, capacity is a defense based on the mental capacity of the accused. Mentally ill people and minors aren't considered to have the capacity towards crime. Self-defense is permitted under Section 34. If you're assaulted without provoking the assault, you're justified in repelling that by necessary force proportional to the force that you were receiving, unless no other option exists where you can then cause grievous harm or death, assuming the threat is imminent. What's a case regarding self-defense? R.V. Lavely. In this case, the use of force was deemed justifiable. This case specifically is about the legal recognition of what is widely considered as the battered woman syndrome, which is a form of PTSD. So the details of this case: Lavely was living with a dude. They had an abusive relationship. He beaten her. He threatened her. He threatened to kill her. And one night, he was assaulting her, and he finished assaulting her, and he was walking away after finishing assaulting her, and she shot him in the back of the head. The court concluded that her actions were in self-defense because the threat was imminent, meaning the threats to her life and the consistency at which they were made justified her response, even though it was after the event took place. They applied that under the reasonableness standard, a reasonable person would be scared for their life due to the consistency of the threat. Now that's important. It's an important distinction to make, because in a case where you're a random woman in Canada, and let's say you get pulled into an alleyway abruptly and assaulted, Uh, whether you are justified in ending that person's life is actually up for debate, because you have stand, no standing, no grounds to think that this threat is ongoing and coming and will be consistent. You have no reason to believe that this is imminent and going to happen again. So the death of that person, if you kill them after they finish assaulting you, is up in the air. Let's move on to a few more defenses. Intoxication, right? Your liability can vary based on your intoxication level. There are 3 levels to this: mild, advanced, and extreme. The extreme intoxication zone is really where actions could be considered involuntary. This can eliminate, not only reduce liability, depending on the judge, depending on the case. Yeah. Let's look at a case for that, right? Davielt versus R. This is a case exploring how intoxication can sometimes be used as a defense, though it remains highly nuanced, right? Just like we were saying, it kind of depends on the case. So in this case, Davielt and this woman they went home together. They were drinking. Davielt drank a ton of alcohol. He was extremely intoxicated. The woman had a drink, she fell asleep, she woke up, and Davielt was assaulting her. After that, he claimed to have remembered nothing about the assault or anything before it other than, getting drunk. Professionals agreed that based on his consumption level, he wouldn't have remembered anything, and so the court sided with Davielt. But the federal government didn't. And why didn't they? They cited Section 33.1 of the Criminal Code. They cited Section 33.1 of the Criminal Code, saying that self-induced intoxication is not going to cover you against the assault of other people. Then we have enticement by police, right? If essentially the accused can argue that the police actions improperly influenced their conduct. Duress, that's the next one. We talked about this earlier. When an individual commits a crime because they were coerced or forced into doing so, that can be used as a defense. But in order to claim that, just like we were talking about earlier, the threat must be immediate. The person threatening the person must be present during the act, so you can't leave the scene and go home and not call the police and do whatever they want you to do. The person threatened must not be part of a criminal conspiracy, so if you're a gang member being forced to do something by another gang member or of a rival gang, it doesn't matter. You can't be part of the gang or any other kind of criminal conspiracy for you to be able to use duress. And the person being threatened must believe that it's going to happen, and you have to prove these things. We have another big one next, so we're just going to go through what we just talked about a little bit. Another defense, we have intoxication. There are 3 levels to it: mild, advanced, and extreme. The extreme level is where actions can be considered involuntary, but under Section 33.1 of the Criminal Code, it specifically says that self-induced intoxication is not going to cover you against the assault of people. Enticement by police is claiming that the police's actions improperly influenced your conduct into doing something, and duress, where you commit a crime because you were coerced or threatened or forced into doing so, but there's a list of qualifiers you need for that defense, right? Finally, we have gone through capacity, self-defense, intoxication, enticement by police, duress, and mistake of fact. Not mistake of fact, that's the last one. So again, we've gone through duress, enticement, intoxication, self-defense, and capacity. Let's go through mistake of fact. What is mistake of fact? It's the defense that you were mistaken of the particular fact of a situation, right? So when it comes to consent, for example, you thought you heard something when you heard something else, or when something else was said. I did a thing under the assumption that something was happening that wasn't. And it's a little confusing, depending on the person, but we'll get into a couple of cases that kind of clarify these. So, Papa John versus R. This is a Supreme Court case regarding a mistake of fact. In this case, there was a victim that met with a business partner. Both consumed a ton of alcohol, and they went back to a house and they had sex. Next morning, the woman ran out of the house with her hands tied behind her back. and she pressed charges, pushed a case upon the man. The defendant attempted to make a mistake of fact defense. Doing that, he was saying that all evidence showed that she consented. Her clothes were neatly folded. Her keys were on the counter. All evidence showed that she consented, but ultimately, despite this, the accused was convicted, and the Supreme Court upheld that conviction. In response to the kind of nuances of this case, though, the government has enacted its own definition of consent. It's very lengthy, and you can look into that if you want. Yeah, sorry, I just had to add the extra details of the case there. Another case, R.V. Ewanchuk. This has to do with consent. Ewanchuk was looking for people to run his little booth, like a food stand or whatever. He met a minor for an interview, and during, and this is creepy, he asked to give her a foot massage. Later, she claimed to be made uneasy by the request. She eventually asked him to stop when his foot massage ended up getting close to her breasts. He stopped and he went back to the feet, which at the time she agreed to. But the situation repeated until he eventually exposed himself. And at the end of it all, he paid her not to tell people. At the trial, he was acquitted on the basis of implied consent. He argued that not stopping him and consistently saying, yeah, you can go back to my feet, was consent. However, the Supreme Court reviewed the case and they deemed it assault. Finally, R.V. Hutchinson. This was a case where the complainant agreed to sex, insisting that he used a condom. He poked holes in it, and she got pregnant. Essentially, two people. They're going to be having sex. Woman demands he uses a condom. He pokes holes in it, and she gets pregnant. The Supreme Court concluded that this amounted to sexual assault, and she didn't consent to this. Even though they agreed to have sex, the consent to all things sexual in itself must be ongoing and consistent. So, again, we had capacity. These are the defenses, right? Defenses and mitigations of criminal offenses. We have capacity, self-defense, intoxication, enticement, duress, and mistake of fact. Criminal Code of Canada. Let's get some background into that. Criminal Code of Canada, the historical background of it. It was enacted in 1892 under the Constitution Act of 1867. And the criminal code has undergone numerous updates to reflect societal changes. It's a federal act that's over 300 pages long, and it kind of has different roles, procedures, and different sections. So, let's take a look at that, right? So, what's its role? It outlines what constitutes as a criminal offense and sets up the framework for prosecution. Looking specifically at prosecution, what are some of the punishments and procedures we look at? In the criminal code specifies the types and degrees of punishments and governs investigation and prosecution procedures, right? So it's not only outlining what constitutes as an offense, but kind of setting out the types of degrees for punishment and investigation and procedures, whatever it may be. Besides the offenses in the code, other statutory law-based crime exists, right? Like, for example, like the Firearms Act or Controlled Drugs and Substances Act, etc., etc. What are some of the offenses included in the code? Like we talked about, offense against person, offense against property. Dogs are included as part of property, by the way, or pets. Offenses against the administration of law, sexual offenses, terrorism, and offenses, and hate propaganda offenses, right? Pretty basic. Again, enacted in 1892 under the 67 Constitution Act. Bunch of changes, 300 pages long, federal act. It has a role for outlining criminal offenses, specifies different kinds of punishment, investigation, whatever it may be. There's a bunch of different kinds of different legislation, right? Like Firearms Act, controlled drugs and substances, and naturally the offenses include what we know to be offenses. Now let's go over this. Let's go over criminal law and sentencing. So within criminal offenses, the criminal code sets out three categories of offenses. These are summary offenses, indictable offenses, and hybrid offenses. Summary offenses are the equivalent of misdemeanors in America. They're typically less serious with expedited procedures and lighter penalties. For these summary offenses, there's a maximum fine of up to 6 months in prison and a $5,000 fine. Um, Indictable offenses, the next one we talked about, these are more equivalent to felony offenses. They're much more serious, and they can have a complex trial process, and they're typically, things like murder, assault, whatever it may be. Um, Intense levels of burglary. The nature of the sentencing in indictable offenses depends on the nature of the offense, right? The criminal code responds to this by laying out, again, these specific punishments for different crimes, right? Like life in prison without parole for 25 years is the punishment for first-degree murder. If you sexually assault someone without a weapon, you'll get 14 years of jail, and the criminal code kind of specifies all of these things. The defense team can make a case of cruel and unusual punishment, though, when the punishment doesn't fit the level of the crime. It's important to note. And finally, hybrid offenses. These are offenses that can be prosecuted as either summary or indictable, depending on the circumstance. And the Crown prosecutor will kind of choose what kind of offense it is between the indictable and the summary offense, right? Why do we sentence people? There's different objectives to it. It has a wide range of purposes, including general deterrence, so discouraging the public at large from committing crimes. Specific deterrence, so making an example of and preventing the particular offender of reoffending. Societal denunciation, so publicly affirming that the behavior is unacceptable. Accountability and safety, we try to ensure that offenders are held accountable and that society is protected. And rehabilitation, we sentence for the purpose of rehabilitating the person as better. So again, the objectives and purposes of sentencing: general deterrence, specific deterrence, social denunciation, accountability and safety, and rehabilitation. We consider a bunch of factors when sentencing. For example, we will consider premeditation, right? The level of planning involved, the gravity of the crime, how severe it is, the offender's profile in court, right? The attitude at the time of the crime and at the time of the trial. If you have a good legal counsel defending you in court, they'll try to shape you in such a way that you kind of take the accusations against you very seriously. You're very serious about the process. You're very remorseful, very serious about the crime, as opposed to being nonchalant or not caring. With regards to the offender's profile, we take into account the previous criminal record. That notion of the previous criminal record, again, matters way more in criminal law than tort law. In tort, it's really only going to matter if you're making vexatious claims. And we got into the definition of that in tort law. Age and personality is considered, right? As well as any other mitigating circumstance that might lessen your culpability. For example, we'll take into account if your probation officer has something good to say about you. Finally, we'll consider past sentences and mercy. So we'll consider the past sentences against you and the application of mercy where it is deemed appropriate. We kind of try to consider the human element of things and, compassion and et cetera, et cetera. So just to go over that again, what are the factors considered in sentencing? We consider premeditation, the gravity of the crime, the offender's profile, including their attitude, previous criminal record, age, personality, or any mitigating circumstances that might lessen culpability. And we consider past sentences and try to have mercy. In class, we went over a case study about the Brentwood stabbing murders. It's a murder in Calgary. Essentially, a guy stabbed a bunch of people after having a string of mental episodes. It's most likely, and now it is, attributed to schizophrenia. Due to this, he was found not criminally responsible under the criminal code, but this kind of raised questions about accountability and responsibility and how far that goes with mentally unstable people and the fairness to that individual in comparison to the victims' families. But that is our lecture on criminal law. I know I rushed a little bit. Don't want to make it too unbearable to listen to. Yeah. We'll wait 10 more seconds so that we're sitting in. 35 minutes. I hope you guys have a fantastic rest of your day. Sorry for the nasal.